Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing of gum, or reading any materials, and also no driving.
Thank you, officer. All right, this is case number 20-165-51, strike at 165-615. This is Affiliated Diagnostics of Oakland LLC versus City of Detroit. Today is date time set on a motion for reinstatement. Your appearance for Affiliated Diagnostics, please. We have counsel for City of Detroit. All right, the court will recall on that matter shortly. All right, the court now calls case number 22-19865. This is Beaumont Health versus Laura Massengale. The matter is before the court set on for a pretrial conference. Your appearance at this time for Beaumont Health, please.
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
All right, thank you, counsel, and good morning to you. I'm looking now for Laura Massengale. If you want to Zoom, please say something at this time. Massengale, I know that I previously scheduled this for a pretrial conference, and then I adjourned the conference date until today's date. Counsel, can you update me on what's going on here, sir?
Yes, Your Honor. I believe the last time you were initially going to ask me to file a default under the 7-day rule, but we decided, however, you decided to give her one more chance to see if she would appear. I would ask that you consider allowing me to do it this time as she's not present. All
right. In looking at the file, I see what I see here is that there was a motion or petition by Ms. Massengale indicating to me that she could not make the previous court date, and that court date arrived before I was aware of that. She had indicated she would be out of town the 18th through the 25th of January. So I did reset the date for the 7th of February, and a notice was sent out in that regard. That notice was sent out on the 18th of January. And counsel, you of course received the notice of this new date. Is that correct, sir?
Yes, I did, Your Honor.
All right, let me try again. Ms. Massengale, if you're anywhere on this Zoom, say something at this time. All right, it appears now that while the court granted a previous adjournment, that with regard to this matter, the defendant has not appeared on the adjourned date. Accordingly, the petition for entry of default at this time will be granted. The record should reflect that the complainant in this matter pleads for a sum of $2,063.93. The court will enter a judgment upon presentment based upon the default in this matter. So ordered.
Thank you, Your Honor. Have a great day.
Likewise. All right, the court calls at this time case number 14-104-696. This is convergence of receivables versus Thelema Vance. The matter is before the court. Where the court set the matter on for a hearing, the record should reflect that the matter had been previously in bankruptcy and under a bankruptcy stay. When the stay was lifted, the petition was brought to bring this matter back before the court. All right, your appearance for convergence receivables, please.
Good morning, Your Honor. Brandon Buck appearing on behalf of Convergence Receivables.
Thank you, counsel. Good morning to you. P number for the record, please.
I'm sorry, I didn't hear that.
Your P number, if you will, for the record, sir.
Sure, P63152, Your Honor.
All right, thank you, counsel. I'm looking for Thelema Vance. If you're on the Zoom, please say something at this time. Ms. Vance, Delaney Vance, person purportedly living on a street in Detroit on Granville. All right, council, notice did go out to Ms. Granville at the last known address that we have in the fourth file, and that is the Granville address. That notice went out on the 18th of January, setting this date as the date for hearing with regard to the reinstated case in this matter. I issued that in an order that was presented. The court added that language, and then we sent out a separate list besides the court's order. Counsel, anything at this time?
I don't think so, Your Honor. We're appearing pursuant to the court's order. The court previously granted our motion to lift the bankruptcy stay, which we provided a copy of the docket. It looks like the Chapter 13 case was dismissed due to failure to make payments. So this case is now reopened for post-judgment collection activity.
All right, and you may proceed accordingly again where the bankruptcy stay has been set aside. All right, thank you, counsel.
Thank you. And Your Honor, one brief question. Are there any other subsequent hearings set on this, or we'll just proceed with post-judgment?
No, I think that what happened here is that I was of the mind that this was something where there may not have been a judgment entered. And so the court was thinking that this was prejudgment. But I am seeing now that the stay was asked to collection efforts. And of course, that stay being lifted, collection efforts can proceed regarding this matter.
Perfect. Thank you, Your Honor.
All right, this is case number 22-196504. This is Universal Collections LLC versus Darla Rena Sampson. The matter is before the court. Looks like the court set this matter on for a pretrial hearing. All right, your appearance for Universal Collections, please.
Good morning, Your Honor. Naltrat Francis P72322 on behalf of Plaintiff's Attorney of Record.
Thank you, Ms. Francis, and good morning to you, ma'am. All right, I'm looking for Ms. Sampson, Della Arena Sampson. If you're on the Zoom, please say something at this time.
Good morning, Your Honor.
All right, good morning to you, Ms. Sampson. All right, so it looks like there was a proposed entry of default in this matter, but I did receive a note that was directed to my predecessor in this matter, the Honorable Lydia Nance Adams. And in this matter, Ms. Sampson pointed out to the court that she rented from Great Lakes property for 3 years, did not believe she owed the company any money, said she was wrongfully evicted at 10 p.m. at night after making payments prior, constantly had to meet with to adjust account to false information, etc. So it seems that the matter is in dispute. The claim here is that there are damages in the amount of $4,181, and I believe that some of that claim may relate to charges after the tenant left the property. Madam Counsel, is that correct?
No, Your Honor. The amount sued for is exactly the same amount that was on the eviction judgment that was entered in 2018.
So this case went through the landlord-tenant court, and there was a judgment that was entered in landlord-tenant court, and that judgment was for $4,181. It was a pay or move type of judgment. Is that what it was?
Correct, Your Honor.
All right. So So Ms. Sampson, there was already a determination that by a previous court regarding that amount. Talk to me and tell me what you wanted to tell me at this time, ma'am. As I set this case up and figure out what we should do going forward. Go ahead, ma'am.
I just, the whole experience of renting from this property, this company, was a very bad experience. And after the eviction, which I was kind of blindsided by because I made arrangements with the property, um, to stay at the property and to not be evicted. So the judgment after the eviction, yeah, I had no idea about and really don't believe that I owe them any money.
All right. Well, the district court, is it that you didn't show up or was there a hearing? What happened in the district, in the landlord tenant court? Because the judge determined.
Your Honor, it looks like as to Miss Simpson, there was a default and a consent as to another occupant.
All right. So yeah, it's when did that occur? What's the date of that?
That judgment was entered 8/27/2018.
And yeah,
2018. I mean, that judgment, that's not a judgment that they could use to collect and come against your resources, but it is a determination by a court that said that at that time, you as well as another person owed that amount of money, and that other person signed it as a consent, but you weren't there in the hearing, and so it was entered against you by default. Um, uh, there's nothing I can do to go back and change that because you would have had to file a motion in that court to get that changed. So that court already determined that there was money owed at the time that you moved from the property. So essentially, what you would have to do as it relates to the money amount is you would have to show that you paid something after that judgment was entered.
right. And I definitely did because we got evicted, what, like September 30th or something like that. So that was after that, and I definitely paid a whole month's rent. And she told me I didn't have to worry about any evictions or any more court hearings. So yeah, that's my fault for, not being knowledgeable on how the court system works and dealing with someone who took our money and still evicted us. So I understand what you're saying.
Well, Judge,
Excuse me 1 second, Ms. Francis. How much was the monthly rental amount?
1,000.
All right. So, Ms. Francis, do you have some discretion? I'd like to send the two of you to a breakout room and see if you could reach a number that will work for both sides, because it's been for 5 years now since.
Exactly.
That doesn't, unfortunately, that don't make money go away. Where there's these kind of obligations, there's a way that the law allows that to continue to go forward. But you may want to see if you could negotiate an outcome to this. I know that it was a trying experience. I'm not making any judgments on either side here. Obviously, the notion, the idea of getting evicted is horrible in any circumstances. Fortunately, this was before the pandemic, but again, even the pandemic is not being disrupted in the place where you live is an incredible challenge. And so now there is this case that's pending with $4,100. Tenant says she may have paid $1,000 after that judgment was entered. Maybe you can negotiate a little bit and see if there's a number that the parties can come to get this resolved. So I want you to try to do that. So I'm going to, you're on my clock, so I'm going to send you to a breakout. I'm going to try to talk about that. And when you're done, just come back in. We'll see if we can get it resolved.
well, Judge,
Appreciate it.
just for her statements, I mean, if she did pay another month's rent, that's probably why nothing more was added after the judgment for September.
1 second, Miss Francis. You for some reason your sound got really cloudy there. I don't want to have. I don't want the parties to have a debate about the sequence of those things. Obviously, what Ms. Simpson is looking for, and oftentimes in these kind of matters, there's room to negotiate. She would like to negotiate on this to see if there's a way to get credit for some things that she believed occurred. And then it has been 5 years. So if there's a way to get there, I want the parties to take a moment to talk about that. If you can't get there, then I'll set it up for trial and we'll figure it out. All right, so there's your notification, Madam Counsel. Go to the breakout.
I do have one more, Judge. Do you want me to go into the breakout room before that one, or?
And let's just see which one that is, Ms. Francis. Is that portfolio?
No, Your Honor, that is credit acceptance.
Credit acceptance? All right, let's see if I can do that one. So Ms. Sampson, you got your notification, just hold tight. And Ms. Francis is gonna come to the breakout room shortly. I'm gonna call this other case that she had to your matter in a moment. All right.
Thank you.
19-15-9644. This is Credit Acceptance Corporation versus David L. Coulter and Sterling Temporary Services LLC as a garnishee defendant regarding this matter. It looks like there has been submitted to me a stipulated order to set aside the failure to disclose. So it seems that there is some action that has been taken in that regard. Your appearance for the plaintiff regarding this matter, counsel.
Najat Francis, P72322, on behalf of Plaintiff's Attorney of Record, Your Honor. Your Honor, that is correct. We did file a stipulated order to set aside the failure to disclose judgment that was signed by both parties. We would just ask for that to be entered.
All right, and that seems to be the purpose that drove this particular hearing as well. That's why I set this up, was because there was a motion to set aside the default. And now I see that there is a stipulation in that regard. Any other counsel regarding this matter on the Zoom at this time for Coulter or for Sterling Temporary? If you're on the Zoom, go ahead and say something at this time. All right, I do see the stipulated order, Madam Counsel, and I am signing that order at this time, and copies will be populated before the day is out. They'll be sent out.
Thank you. And I'll go into the breakout room now. Thank you.
I appreciate that, Ms. Francis. See what you can do, all right? Good day. All right, Mr. Law, somebody sent an email. They actually, it was actually helpful. This is case number 2165615, Affiliated Diagnostics of Oakland versus City of Detroit. This is before the court, set on for a motion for reinstatement, it looks like to me. Counsel, your appearance for plaintiff in this regard.
Good morning, Your Honor. James Lowe on behalf of the plaintiff. My P number is 63110.
Thank you, Counsel. Good morning to you, sir. Let me see first if I have someone from the City of Detroit regarding this matter. City of Detroit, hopefully they're not having the same problem that you had. What happened, Mr.
Your Honor, the notice to appear listed the Zoom ID as 360-534-0000, which leads to the other Judge Coleman's waiting room. It's Judge Alicia Jones Coleman. So Patrick Cunningham, who represents the City of Detroit, we're having the same exact issue. We then coincidentally, both logged into the other link to Alicia Jones Coleman's waiting room, where we were actually appeared in front of either Judge Jones Coleman or her clerk, where they gave, again, your Zoom ID is 360-534-0000. And then I just happened to see an email from Your Honor that listed this Zoom waiting room, and I'm not sure if it got forwarded to Mr. Cunningham or not. I literally, once I got your email, I tried calling Mr. Cunningham twice, and he and I have been talking this morning. He's not necessarily opposing the motion, but I don't like going forward with motions without opposing counsel here in any event, whether they're opposed or not.
So yeah, I mean, a large part of this is secondary to my getting transferred at my request to a courtroom. That's the courtroom number is 534. When I was transferred to that courtroom on my request, I made the assumption that seemed to make sense to me that the Zoom number would correspond to the courtroom number. just as the 336 corresponded to me being in that court. That was bad. So I am in 534. That's my court. But for some reason, they did not give me that Zoom number. So my Zoom number remains my previous courtroom number, and that's 336. So all of the notices that will go out subsequent, because I'm looking at the notice that went out on this. This was before I found out that they weren't changing the number. All of the numbers that went out had the 534, my courtroom number. So everything you'll get going forward will always have that 336 unless something changes. But that's where I am. 336 is me. So I'm glad somebody sent an email, and I would suggest that you come across anybody that you know tend to come here that you tell them it's 336. But again, all of our notices have been changed. Anything that has gone out this year is 336. Your notice went out in December, so still 534. So that's and it had nothing to do with you. And then and you know how things get, you know how complicated things have a tendency to get. That Judge Alicia Jones Coleman was not on this docket when all this change was made. So then she gets transferred to this docket, and lo and behold, her number is 534. They give her that number. So now you got two Colemans, and you got this confusion. But yeah, it's been it's been an interesting little journey. So that's the long and short story. All right. So with regard to this matter, I guess you want to take a moment to see if Mr. Cunningham, if you could reach out to him.
I can try to, Your Honor, I can try to reach him one more time. When we both were still in the state of confusion this morning, he had suggested that we do this by stipulation because he said he wasn't opposing my motion, and it seems like the case was, inappropriately dismissed administratively. But if the court would be willing, well, I'll try to reach Mr. Cunningham one more time. But if I can't reach him, if the court would be willing to put this over for a couple of weeks, but in the meantime, if the court's willing to sign a stipulated order to reinstate, that would be easier and it would eliminate the need for the next hearing.
Yeah. I mean, on your representations, and I know, of course, Mr. Cunningham as well, that and this is a case that would likely be reinstated anyway. So it makes sense that that's what the parties will be talking about. I will simply set it over for a couple of weeks in anticipation of the submission of a stipulated order.
Okay, yeah, I'll instead of trying to get a hold of Mr. Cunningham now, since I've already tried to call him twice in the last 15 minutes, why don't we just put it over for a couple of weeks? If you could just give me a return date, and I will pass that on to Mr. Cunningham also.
Sounds good. I'm going to go ahead and set it on the 28th, council. Actually, the 21st.
Okay.
So 220, 221, 23. I'm going to set it at 9:45 again.
9:45, and the Zoom ID is the 336. Got it. All right. I will let Mr. Cunningham know of all of them, but hopefully we'll get the stipulation into Your Honor so that it won't be necessary in any event.
Sounds good. All right. Thank you, sir.
All right. Thank you, Your Honor.
I'm looking for 22-193-726 Portfolio Recovery Associates versus Barbara Jones. The matter is before the court, set on today for a motion to set aside a default judgment. Now, the court went ahead and set this for hearing on today's date. All right, your appearance for portfolio, please.
Good morning, Judge Coleman, Cezanne Barta, P65425.
All right, thank you, counsel. In your appearance for Barbara Jones on the Zoom, please.
Good morning, Your Honor. Attorney Morgan Alexander, P85755 on behalf of Ms. Jones, and she is with me here.
All right, thank you, Ms. Alexander. I love the combination of that name, Morgan and Alexander.
Thank you.
All right. Well, this is, I think, your motion to set the default aside, although it looks like it was a handwritten motion by your client. Go ahead and tell me why you believe, why you are asking the court to set this aside.
Yep, I did have an opportunity to speak with opposing counsel in a break room prior to the start of court today because I wanted to request an adjournment to allow for me to go ahead and submit an amended motion. And primarily on the basis that at the time of that debt, Ms. Jones was enrolled in a program with the bank and believes that that debt has already been paid off. So if we could have just an opportunity to collect those statements and file an amended motion, that would be our request.
And plaintiff has no objection to that, Your Honor.
Yeah, that certainly makes sense. Anything that might lead to some meaningful resolution, really is. All right, so how much time you need, Madam Counsel?
30 days should be more than enough.
I think so. All right. I'll go ahead with the 30 days. We'll go ahead and send it over for. Yeah, let's put it on the 9th of March 9th.
March 9th.
And that's going to be set that up for 10 o'clock a.m. March 9, 10 o'clock. And I don't know, did you you got the Zoom number, Mr. Bart, I guess you got it also. That your notices that you got from me, yeah, correct, 336 on it?
Yes.
Yes.
That must have been a notice from this year, so you see the kind of problem that we try to clear, right? It just, not to criticize anything, but it just seemed common sense to me for them to allow the Zoom number that corresponds to the courtroom to follow me, particularly where that was Judge Adams' courtroom.
Your Honor, as soon as you fix the problem, they're going to switch your Zoom to 534.
So you know, boy, but you saw the double layer or the triple layer of problem. Then and after all of this, they put Alicia Jones Coleman on the civil docket, and she ends up with the 534 number in my previous courtroom 336. So now she has courtroom 3365, Zoom port 534. I had notices out with 534. Ended up in Judge Coleman's courtroom. That's not Judge Coleman. So anyway, we're gonna get. As long as you know, I'm 336 right now.
Got it.
Got it.
So I'll see you all the next time, 39 at 10 o'clock. All right, good day to you.
All right,
Thank you.
Thank you, Mr. Rice. I'll be right with you and Ms. Simpson.
What's that noise?
No, hope it's not water running.
Sounds like water, yeah.
All right. We're back on record regarding the subject 6504 Universal Collections LLC versus Delrina. I don't know why that's so hard for me. I think
It's Delrina.
just Delrina.
Yes, that's it.
So, problem is that I'm trying to put another syllable in there.
Mm-hmm.
Thank you, Ms. Sampson. All right, Ms. Francis, update me if you will at this time.
Snapchat Francis, once again, Your Honor. Your Honor, we were not able to come to a resolution. Ms. Sampson doesn't believe she owes anything.
She doesn't. I'm sorry, I didn't hear the last part.
She had stated she doesn't believe she owes anything, Your Honor.
All right. That is that your position in this matter, Ms. Sampson?
Yes. I mean, she wanted to like take something off of that amount, but I don't know. I can't.
All right, got it. All right, so what I'm going to do now is to set this case up to try and get us to trial as soon as it possibly can. The next step is what's called discovery process. That's where both sides can request from the other side under the court rules documents that may be held by the other side that they intend to use at trial. This gives both sides the opportunity to discover any information that the opposing party may have that they might wish to use at trial. So Ms. Francis, are there documents that you're going to be requesting, any interrogatories or requests to admit anything by way of discovery that you might be seeking?
I believe so, Your Honor. And we will most likely file a motion for summary disposition as well.
All right. And Ms. Sampson, are there any items that you believe are under the control of Universal Collections of Great Lakes that you need as a part of helping you with your case?
Absolutely.
All right. And what are those items? If you can tell me now, I can order that those items returned over to you. What are you requesting, ma'am?
They have all my payment receipts, all documents, communicating with them as far as removing several of those fees that are included with the amount that they're suing me for. And I'm sure that they have all documents of all that information that would show that, yeah, I don't owe them this much money.
All right. So you want, so you're asking the court to allow an accounting for them to provide the monies that you paid during the term that you were there, and also you want them to produce any written documents showing any communications in writing that you had between you and them or any of their agents. Is that correct?
Yes, sir.
All right, so I'll order that be done, and I'm going to allow discovery to occur. If you think of some other things that you want from the other side, it has to be relevant and it has to be something that's under their control. Then you can certainly request that in writing, put it in writing, and make a request for it. I'm going to allow that discovery to take place through the 24th, the 27th, through the 27th of March, 3/27, 23. Actually, I think that's right. Let me have you back on April 4th. 4/4. So discovery will be open until 4/4 of 23, and that's going to be at 9:30 a.m. You'll get a scheduling order from me in the mail, and it will allow for discovery that will set that date as the end date for discovery, and it will set that date as a hearing date at 9:30 a.m. It also has a paragraph 6 that allows for the parties to file motions. If there's a petition that you're asking of the court, then you have the right to file a petition and make sure that the other party gets a copy. And I will hear whatever your petition is on the 4th of April. If you motions fit into two categories. One, non-dispositive, meaning that it's not a motion that would end the case. It's requesting something like discovery or something along those lines. And then there's a dispositive motion, meaning a motion that could end the case. So oftentimes motions that are dispositive are called motions to dismiss or motion for summary disposition. Either side can file such a motion and set it for hearing on the 4th of April. The only requirement is that you give at least 10 days notice to the opposing party. So if you get something that tells you that that you're asking the court to do something, you'll have the 10 days before the hearing to respond to it. And I will hear it on the 4th of April and make a decision as to the outcome of that motion. So you'll get that in the mail from me. It will say the same thing. Just want to go over that with the parties. All right. Anything else at this time?
Sorry, Judge, you said April 4th at 9:30 is the next pretrial and close of discovery
That's correct. That's correct.
and a motion hearing date?
That's a motion hearing date with that one requirement. You gotta make sure the other party has at least 10 days to respond to your motion.
Thank you.
Thank you. Good day to both of you. I'll see you on the 4th of April.
Thank you, Your Honor. You too.
Thank you.